I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Welcome. We'll begin by reviewing the draft minutes of our previous meeting. That was held August 21st, 2023. I make a motion to approve the draft minutes without correction, deletion, or additions. Would a member second? I'll second. Thank you, Patricia. All in favor? Aye. Approved without amendment. We'll review the agenda as posted on the town website. Noting first that the application for 12 Pickering Lane has been formally withdrawn. There's a public hearing for 63 Indian Creek Lane. The hearing is to appeal a code on officers' interpretation. Next, we have two items of new business. 15 Green Street, which a lot proposed residence is going to be on 1.4 acres, where it's required in the R9 zoning district to be 0.2 acres. And then the second new application tonight, 444 Farm to Market Road. The applicant is proposing a 2,400 square foot accessory barn, where the code is required for 1,500 square feet. And I would like to propose that the board shuffles the order of the agenda and takes on the two new applications before the public hearing in order not to hold up those applications and to have time for the public hearing. Does anyone have any questions or concerns about that? No. That is what we will do. Thank you. So in order that they were received, we'll start with 15 Green Street. The applicant here, come on up, please. How are you doing tonight? We're glad you're here. Thanks for coming to our meeting.
Thanks for having us.
Yeah, you're welcome. Want to give us a little brief overview of your proposed project, please?
Yeah, we're going to put a single family raised ranch there.
And what's the issue? Why are you here in front of us?
We don't meet the R9 zoning requirements.
So,
The lot is a little too small.
okay, and how too small?
It's just under 6,000 square feet, and it's supposed to be 9,000.
I'm sorry, are you Ann Cole?
I'm actually right there.
Okay.
He's my partner.
Okay, great, thanks. So we have a letter from the property owner giving authority that you can represent him.
Yes, ma'am.
This is a really well put together application. I want to thank you and the building department working on that together. Just have a couple of questions here. So you're staying within all the setbacks, so you're not requiring any setback area variances? Do you know the history of this parcel? Was it ever developed?
The piece of land itself, I know that on the original survey, there was a partial piece of fence and a small shed on there, but nothing more than that. We went and looked at it, I didn't see any remnants of past development, so I'd say no.
Okay. So do you think it was part of a neighboring parcel?
Could have been bought with one of the neighbors. They sold off. I know the house to the, looking at the lot, the house to the right of it has an extra lot with their home that they own to kind of extend their yard. There's a few development like that.
What is the square footage of the house that you're proposing?
Just under 2,400.
I think it's right around 2,000.
The footprint is around 40 by 30. Two-story, raised ramp, so you have the garage on the first floor.
So it's a side load garage?
Front door.
Oh, because in the plan that was provided, it's showing the garage coming in the right side.
It'll be a front load.
Okay, so we have a plan that was like this.
Yeah, we do have to make some modifications to it, so it would be a front load. There wouldn't be access actually from the side.
Okay, because that was my question.
Yep.
Like if it was
Yes,
on a
ma'am.
side load, then
Yep.
how would the driveway fit in that? Okay,
Yeah,
so-
we didn't want to put thousands of dollars into a set of plans we weren't going to get approved, so we took a plan that we had, that our architect has worked with before, and then he was going to modify it after the approval. The sale of the lot is contingent on this being approved.
Are there any other questions for the applicant at this time? So the application appears complete for the purpose of holding a public hearing, which we'll do in our next meeting in October. So it's, again, it's the third Monday of the month, and we'll begin by 6 o'clock. So it will be on for 6 o'clock.
Great.
Yeah, thanks. And the zoning board members like to go out to the site and to visit. Do you give permission to the members to go out and visit the site?
Definitely. 100%.
Okay, well, thank you very much.
All right,
And
thank
if
you.
you have any questions between now and then, you could just direct it to the building department. and
Okay.
get
Yeah,
back to
any
us.
questions for us, feel free to reach out.
Okay, thank you very much.
Thank
See
you so
next
much.
month.
Have a good night.
Should be October 16th.
60,
16? All right, we have our calendar.
6 o'clock, okay.
All right, thank you
All
so
right,
much.
thank you, have a good
Enjoy
night.
the rest of your meeting.
Thanks, yeah, see you then. Right, so next up, we have 444 Farm to Market Road. Mr. Larry Mackey, you kindly join us and just give us a brief overview of your proposed project. Yes.
Before we start, I'd like to recuse myself.
Okay,
I don't feel like I could be objective.
okay, John, thank you. We'll do that for the record, and we'll call you back in when Mr. Mackey is done.
Like to build a 40 by 60 ballroom. Cold storage.
And if I believe correctly, this application meets all the setbacks as well.
Yes.
So the only area variance that you're requesting is the size.
Correct.
Yeah, I appreciate the work that you did on this application, really good survey. Would you happen to be able to provide like a rendering of what you're proposing? It can be as simple as you yourself writing it down. The other applicant had what looked like like a model drawing, like a drawing
building.
of the building that you're proposing.
No, I didn't do any plans or anything yet. It's just a pole barn. It'll be metal, a double slider in the front. It'll be a colored one, not a red, it'll be tan or something to match in the woods.
Mhm.
Some sort of brown or tan, just a square, rectangle.
What is the height, do you know?
They'll hit it 20 feet to the top of the peak.
And it'd only be one story?
One story. No attic trusses, nothing like that.
On the environmental assessment form, you did mark that you were near wetlands. Does any portion of the site contain wetlands? Is that in there?
Yeah.
It's page 2, item number 13, because I just didn't see anything on the plans.
You got a survey. Isn't that environmental?
I'm just asking
Oh.
that you checked. Yes,
Well,
Item
it's
number
stated, because
13.
It doesn't test, it doesn't touch any wetlands. And of course, with this site.
I don't, so that last page that the applicant went through, this is something that DEC preloads for environmental assessment forms. So for the site, there must be some regulated wetland or regulated water body. But you've marked that the actual proposal does not impact the water body. Is that
Correct.
Yeah.
There's no water on the property, I don't know what that, okay.
Yeah,
okay,
it may be in proximity, but
okay.
that those answers are preloaded by DEC.
And Gary Joy's Pond's the closest thing to you. And,
That's ways away.
yeah, oh, yeah. And you're uphill from it.
What is the square foot of your actual house?
I think it's 2,400 or 2,300.
I don't know.
Yeah, so again, this application appears complete for the purposes of holding a public hearing, which we'll do next month. What was it, 16th, October 16th? And the application before you will start at 6. They generally go for about 15 minutes or so, so I'll put you down to 6:15.
650. Okay.
And if there's any questions before then, you can address the building department, you can get a hold of us.
That's it?
Will be good, yeah?
Perfect.
Okay. Oh, I'm sorry, yes, and the zoning board members would like to visit the site, if that's okay? Yeah.
Absolutely.
All right, we can sometime give you a heads up with a phone call or,
Did you drive up?
Okay, good.
All right.
all right, thank you very much.
Thank you.
Have a good night.
Yeah, you too.
Thank you.
I don't know how much is garage of this, Patricia, but I came up a little under 3,000 for the
Was
house.
the garage added on after? Is that what I read in the application?
Quite
That
possibly,
it
but
originally,
yeah, that's
built
on,
and
that's
then-
on the north side of the house. So. Then there's a detached as well. So.
All right, so we're done with our 2 new applications for new business. We'll move on to our public hearing for 63 Indian Creek Lane. So Joe Press will sit down, and Christopher Lamoy, who is serving as special counsel to the zoning board for this appeal, will join the zoning board. For the record, Patricia Kern is recusing herself on this appeal. And so is Chuck representing the building department. So just to give a brief summary of how this will go, the zoning board will open the public hearing. The representatives for Mr. Charles Wilson will have opportunity to address the merits of their application and their appeal. Then the presentation of the code enforcement's perspective will be given to the zoning board. Then after the zoning board has heard from both perspectives, we'll open the floor for public comment. And then if anyone else would like to speak for the code enforcer or for the applicant, we can do that after that time as well. So there's plenty of time to offer your concerns and comments. So the zoning board will open, sorry,
Do we have everybody? So Pat Curran recused herself.
right, and John Miller is absent.
Okay, so we have a quorum of 3 of the 5 members here tonight.
Yes.
So just thinking it through, so 4 members are available to determine the appeal because 1 member is recused, that means 4, but you only have 3 here tonight. So that gives you a quorum, you can conduct business, you can hold a public hearing. What I'm not sure about is if the member who is not here for the public hearing, whether it would be appropriate for him to deliberate and decide on the merits of the appeal because he wasn't here for the benefit of the public hearing. I have to take a look at that. So if you had 4, I guess it wouldn't really matter, right? Because you have to have 3 to make a decision one way or another, either to affirm, either to affirm the decision or to reverse the decision. You have 3. So I guess it really doesn't matter. I'll have to look and see whether or not the absent member can participate in the determination if he wasn't here for the public hearing. So a very long way of saying you can proceed.
So the zoning board will open a public hearing on this application. I would ask the representatives for Mr. Wilson if they'd like to come up and speak about the merits of their appeal.
Thank you, Chairperson. Good evening. My name is Bob Tejan. I'm an attorney who's been representing Mr. Bolson throughout the course of his appeal. And I just want to, I think that the public notice framed it appropriately, that this is a question of how to interpret a particular zoning board regulation. And I think what I'd like to do is just go through a little bit of the timeline, which I think is appropriate and relevant to what's going on here. So this all started back in 2017. Mr. Bolson submitted a building application to the town, and that application listed an accessory structure, a barn, and it listed a square footage of 2,000 square feet, and under the intended purpose, it was indicated agricultural. In October of 2017, the town granted it provided the building application to Mr. Bolson. Subsequently, Mr. Bolson paid a fee of $310 to the town, which it accepted. That would represent the amount of square footage over the 1,500 square feet. And then I think in 2020, he paid $100 for a renewal fee for that initial application. So at that point, the town was on notice that this was a building that was going to be used for agricultural purposes, and that the building exceeded the square footage requirements of Town Code 160-29. The town, based on that information and full knowledge of it, granted him his building application. And our position is at that point, Mr. Bolson obtained a vested property interest in building his barn without the need for a variance because of the exemption under 160-29 for agricultural buildings. And that's where I think we get to the interpretation of that statute. I guess it's a regular zoning law. So 160-29 has, I think, the relevant restrictions here, where it says that except for agricultural buildings, you can't exceed 1,500 square feet in square footage without a variance. Okay, so it accepts agricultural buildings from that requirement. That was known to Mr. Bolson, it was known to the town when he was granted that. We believe that gave him a vested property interest. It wasn't until April of 2021 that, for the first time, Mr. Bolson was informed that he was issued a stop work order and told to do several things, including apply for a variance. That began a somewhat convoluted process that's extended from 2021 until today, where Mr. Bolson attempted to make his position clear that he did not have to, that he was exempted from the variance because of the fact that it was an agricultural building. Here we are today. Finally, Mr. Golden did issue a denial. That's, I think, what got us in front of the board today. And our position is, because it's an agricultural building, he's not required to apply for variance. Now, Mr. Golden has admitted, and we've searched the town law, there is no definition of an agricultural building within the town code. There's no requirement in the town code that any affirmative showing of agricultural business be demonstrated by a landowner who's seeking to use this exemption. And there's certainly there's no requirement that the applicant be state certified or the state agricultural district in order to qualify for this. Mr. Golden, and this is all within the record of what we've submitted, has admitted all this. And the only authority that he's provided, Mr. Golden provided for Mr. Bolson, was a state regulation that had a definition in it of an agricultural building that said any building that's used to house or farm implements. That's what's being done here. Mr. Bolson has submitted official documents indicating that he's going to use this for agricultural purposes. He submitted sworn testimony to that effect, and the physical attributes of the barn in question are consistent with the use of agricultural building, in that there's minimal electric, minimal plumbing, it's not hooked up to the sewage, it's got a second floor, but you need a ladder, there's a trap door. It's consistent with agricultural use. It's completely inconsistent with other uses such as human habitation. The lack of a requirement for any type of showing to qualify for this agricultural exemption, I think is, first of all, it's clearly not in the regs. The town in the summer of 2022, I believe it was, the planning committee suggested some amendments to the town code that would add a requirement that in order to qualify for the exemption, one would have to show that you were a state certified district, but that was never passed. And so that requirement does not exist today. So in the record before the board, the only evidence is Mr. Bolson's sworn testimony that it's in agricultural purposes, his representations in his documents, and the physical attributes of the building itself. We have nothing on the other side to suggest somehow that information is wrong or incomplete. And given the clear law in New York State that any ambiguity within a zoning regulation be construed against the municipality and in favor of the landowner, here, I believe, would suggest that Mr. Bolson be granted the exemption under 160-29, because here it's not even an ambiguity. There's no ambiguity to the extent that that requirement is given, that he has to make some sort of affirmative showing. That would be actually grafting on additional requirements that would be beyond an ambiguity, and I believe would be arbitrary and capricious. And again, when he was granted the application to begin with, he obtained a vested property interest to build the structure. He has not completed it. It's substantially complete when he got the stop work order. He hasn't done any work on it since. It's just sitting there, and we would request humbly that the zoning board allow Mr. Bolson on his property, which is also zone A40, is agricultural, to simply continue to build and finish building his barn. I'm available for any questions that the board might have for me.
I think it's in the appeal case, but just to clarify, can you tell the board members what the intended agricultural use is of the structure?
Sure. First and foremost is to house, farm implements and equipment. He's got tractors, he's got loaders, he's got sort of, heavy equipment that he's going to be storing in there, which is consistent with the regulations that were given to him by Mr. Bolton, the state regulations of housing, farm, construction and farm implements. He's also contemplated various different things. He's got a lot of property out there, so timber. He was thinking at one point about, maple syrup, but it's a little bit to the extent that it's putting the cart before the horse, because he's got to have the barn in order to pursue these endeavors. It's not finished right now. It's not ready to be used. He's got to finish it, and that's what the record reflects, and that's what he's going to do.
One more, again, just to clarify for the record.
Absolutely.
And I appreciate the fact that your position is it doesn't matter, but is there currently any agricultural business being conducted on the property?
Well, according to the regulation that he was given, the answer is yes. It's being used to house and store equipment right now, which is consistent with the state regulation that an agricultural building is anything used to house farm equipment, which is being used right now. But other than that, the answer is no.
Do any board members have any questions for Mr. Teachin at this time?
I do.
Here's what I think we're gonna do. We're gonna hear from the applicant. I think we're gonna hear from the code enforcement perspective, and then we're gonna open it up to general questions, not questions, but comments. So the public hearing, you don't really get to ask Mr. Teachin questions, but if you want to address the board and make a statement, you'll be allowed to do that. Does that make sense?
Absolutely. And would I have a chance to come up and address anything that's said?
To a point, we're gonna let everybody have as much time as they feel they need to stay with us.
Very good. So thank you very much for your time this evening. If there are no other questions, I think, our position is just that he's got the property interest and he should be allowed to finish the plan. Thank you.
With the representatives of the code enforcement, I'd like to come up and give their perspective.
Yes, may I approach?
Yes, you may.
So Andrew Gilchrist, I do serve as counsel for the zoning board. It's been clear in this record that I recuse myself, as I did provide legal counsel to the building department on the underlying matter at issue on the appeal. The town attorney, Thomas Chaffee, will present the interpretation, the legal interpretation of the Brunswick zoning law of the Brunswick Building Department. I will not be presenting any analysis of the Brunswick zoning. Obviously, I'm not presenting any legal counsel to this board. I've recused myself. We'll let the record be clear that separate counsel has been retained to provide legal counsel to the board on the appeal. What I would ask the board to consider, though, is to allow me to present public records that are relevant and pertinent to the legal analysis of the zoning law that Mr. Chaffee will present. The records that I'd like to submit to the board for its consideration are public records. By and large, they consist of Town of Brunswick municipal records. I'd like to ask permission of the board to provide those to the board for its review for the record, certainly a copy for Mr. Bolson's attorneys as well.
Certainly, permission to do that.
it easier for everybody to see. We'll let the record reflect that I'll provide one clean copy for the record. I will be providing 4 copies for the zoning board members' use. I'll provide 1 copy for the zoning board's retained special counsel. I have provided 1 copy to the appellant, and 1 copy will be provided to Mr. Chaffee so we can have that during this presentation of the zoning interpretation. So as indicated for the record, the town building department has handed up a series of exhibits, and I'd like to just briefly step through them to provide some context. The appellant did go back to 2017, presented the submission of the building permit application. These public records likewise go back to 2017, but they go back and include planning board documents that the town building department it determines are relevant to the analysis of the Brunswick zoning law, particular to this matter. The first record, which is identified as Exhibit A, is a site plan application submitted to the Brunswick Planning Board. This is dated May 5th, 2017, and was submitted by Charles Colson. And the address of the site was 63 Indian Creek Lane. Within that document, we just draw your attention to the environmental assessment form, which lists a proposed description of the action that was the subject of the site plan application as a tourist home. And also included at that time was a concept site plan that's in color within Exhibit A. It depicts 63 Indian Creek Lane, and it depicts a proposed layout for the tourist. You'll note on the title block for the concept site plan, it's identified as Indian Creek B and B. Within Exhibit B are a series of planning board minutes at which the Brunswick Planning Board reviewed this site plan application. These are submitted for purpose primarily of representations by the appellant here, the applicant there for the site plan, as to the use of his property. And again, briefly, the April 6th, 2017 meeting, the minutes reflect that the appellant's then attorney, Mr. Angster, and Mr. Bolson explained that Mr. Bolson owns 2 adjacent properties located off Indian Creek Road, one of which totals 140 acres of mostly forest, which has an approved forest management plan. That was the extent of, at least reflected in the minutes, of what the appellant had represented was the use of the 140-acre parcel. The minutes do reflect he owns an adjacent 20-acre parcel on which his residence is, and on which he had applied for site plan approval for the tourist. The minutes go on to reflect that Mr. Bolson stated he would offer the 140-acre parcel to patrons to allow them to walk the property and enjoy the forest area. The minutes reflect that the planning board considered this to be a commercial site plan. The minutes then go on to reflect that Mr. Angster and Mr. Wilson stated that the proposed use would constitute a bed and breakfast under the town's new proposed zoning law. To place this in context, of course, this is April of 2017. The town of Brunswick adopted a new zoning law in June of 2017. It had already been proposed for adoption. And the minutes reflect that the appellant was aware of the new zoning law that was being proposed and considered that its use would constitute a bed and breakfast under the new zoning law. The May 18th, 2017 minutes then indicate that the applicant, here the appellant, stated that the use of the tourist home is intended to be for small groups wishing to enjoy the 160-acre forested area on the property. He explained his marketing plan and use of a website to advertise the venture. The applicant stated he was marketing to small groups, particularly businesses where groups would be getting together outside of the work environment. The June 1st, 2017 minutes. I'll leave those to your review. One of the primary issues that the planning board was looking at on the site plan application was the adequacy of Indian Creek Road to support the proposed venture. That continued during the June 15th, 2017 planning board minutes. On the July 6th, 2017 planning board meeting, this was the first meeting following the adoption of the current Brunswick zoning law, which had occurred at the end of June 2017. I will note we have included within the exhibit package at Exhibit C, the local law adopting the current Brunswick zoning law. This was filed in the Department of State on June 28th, 2017. So the July 6th meeting was the first meeting after the adoption and enactment of the new Brunswick zoning law. The July 6th minutes indicate Attorney Angster acknowledged that when the application was filed, the applicant was aware that a new zoning law was then under consideration. There was some discussion at this meeting as to what law would be applied. There was also discussion regarding an application for a special use permit for the project, and the applicant believed he would be entitled to a variance. The last set of planning board minutes are the July 20th, 2017 minutes. Here, strike that, that was incorrect. This is the penultimate, this is the second to last set of minutes. The July 20th minutes indicate that the application submitted by Mr. Wilson for the property of 63 Indian Creek Lane upon the request of the applicant was adjourned to the August 3 meeting. Now, timeline is an important piece. This is a July 20th, 2017 meeting. We have included at Exhibit D the building permit application that's at issue on the appeal. You'll note that the building department indicates that the building permit application was received on July 21st, 2017. The day following the July 20th planning board minute at which the application review was adjourned at the request of the applicant. We have included the building permit application at Exhibit D. This copy does include the action taken by the building department. That was is at the bottom of the first page of the form, as well as on the second page of the form. The record clearly reflects that the building department issued the building permit at issue. This was done later in 2017, October 16th, 2017. That's reflected on Exhibit B. We'll let that record speak for itself. It does indicate that the present use of the property was agricultural, and the proposed use of the property was as a tractor shed. Also included in the building permit application was a schematic, what amounts to a layout of the appellant's property. It was hand-drawn where the proposed building. It's depicted as a rectangle, noted as ag, build. That was included within the building permit application. There is a stamp. You'll note on the right side of this document, July 21, 2017, as having been received by the building department. The last set of planning board minutes we've included in Exhibit B were from August 3rd. This was following the submission of the building permit application. Here, the appellant is now stating that he conducts a timber operation on the property through a forest management plan that has been approved by DEC, and that the appellant's proposed use of the tourist home would constitute agritourism under the new zoning law. We next direct your attention to Exhibit E. Later in August 21st of 2017, the appellant submitted an amended site plan application to the planning board. This is just the single cover page of the application. Marked on the application form is permitted farm operation, permitted accessory use, agricultural tourism. And this was received by the building department. You'll note the stamp at the top of the page, August 21, 2017. The next document we draw your attention to is from the Town of Brunswick Building Department. It's the next day, August 22, 2017. Here, the building department acknowledges receipt of the amended site plan application, noting that there is a farm operation on the property. The building department requests of Mr. Golson, please provide information on what you consider a farm operation on that property, and also provide all details of farming activities associated with 63 Indian Creek Lane. Once received, I will be able to render a decision based on your current site plan proposal and convey that to the planning board. The next document we've attached as Exhibit G is the appellant's response. This was received by the Town of Brunswick Building Department of August 29th, 2017. Here, the appellant states, our farm operation consists of harvesting and production of maple sap and syrup. Invites the building department to call him. Next, attached as Exhibit H, is a follow-up letter sent by the Brunswick Building Department to Mr. Golson September 20, 2017. In that letter, it acknowledges receipt of Mr. Golson's response dated August 29th, strike that, received by the building department on August 29th, and requested additional information. Among the requests for additional information is When did you begin harvesting and producing maple sap and syrup on the site? What area of the land and what acreage is devoted to maple sap and syrup harvest and production? And also, what is the amount of gross annual sales of the sap and syrup? Please provide proof of receipts. We'll note for the record that this inquiry by the Brunswick Building Department was coterminous with the pendency of the building permit application, which had not yet been acted upon by the building department. It did not come until October of 2017. The record will reflect that the building department did in fact issue the building permit for the structure at issue in October of 2017. We will get to a further municipal record which indicates that the building department identifies the issuance of that building permit as having been done in error, as they were not cognizant, given the new Brunswick zoning law, of the size limitation for accessory structures, as there had been no accessory structure size limitation in the prior Brunswick zoning ordinance. We'll review that in a moment. Next, attached as Exhibit I, is ultimately Mr. Olson, the appellant here, in a submission received by the building department the following February 26, 2018, answered the questions posed by the building department in its prior letter from September of 2017. Here, the appellant represents to the building department that he began with maple sap and syrup production in 2017. He indicates he would show through a site visit the area devoted to maple sap and syrup production. And he does indicate that there were $10,280 in gross annual sales, inclusive of syrup and agricultural stock and product. He also identifies the equipment used in the operation. Upon receipt of that response, approximately a month later, the building department responded to Mr. Wilson through a letter dated March 26, 2018. This is attached as Exhibit J. And in that letter indicates, please be advised that upon review, the town is not in a position to make a determination that a farm operation exists on 63 Indian Creek Lane based upon the information you have provided. Frankly, we found your responses to the questions we posed to be largely incomplete, lacking reasonable detail, and totally lacking in the documentation requested. And asked if you wish to submit additional information in support of your claim, you may certainly do so. Now, the next document, the record does not reflect a further submission by Mr. Wilson in response to the building department letter of March 26, 2018. The next record we put in the document exhibit package is the April 9th, 2021 letter of the Brunswick Building Department, which accompanied a stop work order issued by the building department for the site in question. We'll ask the board to take a review of that letter indicating the bases for issuing the stop work order. Now, the next document in the exhibit package, that being Exhibit L, is a report of a site visit that was undertaken by Charles Golden of the Brunswick Building Department of 63 Indian Creek Lane. We'd like the record to reflect that this report of site visit was not prepared at the request of me, of Town Attorney Thomas Chaffee. He can confirm that on the record as well. To our knowledge, he was not directed by any town official to prepare this report. We were not cognizant of this report until after it had been completed and provided as part of the public record. Mr. Golden did conduct a site inspection on August 25th, 2022. Following that inspection, this report was prepared. You'll note that there are several entries over the course of several months. I don't know when this report was prepared. It had to have been prepared after November 16th, 2022. That's, or at least in part prepared on or after that date, as that's the last date in Mr. Wilson's timeline in his report. You will note two things here. Ask that the board do review that report in detail. The building department report does include a series of exhibits. I'll give the board advance notice. These exhibits do not appear to be in appropriate letter order. It is mixed up a bit. It's been produced for you in the manner in which it sits in the Brunswick Building Department file. Two things we want to point out on the report. At the bottom of page 1, next to the date October 16, 2017, this indicates an accessory structure permit granted for a 40-foot by 50-foot ag storage building with no plumbing, minimal electric, strictly for the use of storage of tractors and large equipment. He references Exhibit I, then writes, permit given in error. I was not aware that there was a maximum size of accessory structures. Last, I point your attention to the third page, which is his conclusion, where Mr. Golden writes, in summation, the applicant has not forwarded any reasonable evidence of his agricultural exemption, so he will have to get a variance for the size of the barn. Within these exhibits, I do want to point out there are pictures, so you're aware of what the structure at issue is, color pictures that were included in Mr. Golden's report. So the first one is just an exterior picture of the barn. That's within Exhibit L. There's also a picture of the interior of the barn, what appears to be the second floor and the roof area. Now, admittedly, this is simply photographs included within a building department report. I have no knowledge whether these are true and accurate. I simply have submitted them to the board as they are part of the building department's record. Next, I would draw your attention to the second sleeve that's within Mr. Golden's inspection report. So the appellant is aware, and the record is clear, within Mr. Golden's report, there were two large maps. We had those copied, and for ease of use, we folded them and put them in a sleeve within the report. The second sleeve contains, well, the document immediately preceding that second sleeve was submitted by, the appellant. It's a document dated June 29th, 2022, executed by Herman Polcher, land surveyor. The second sleeve includes what purports to be a map prepared by Mr. Polcher, and it identifies the location of where the structure exists on the property. I asked the board to take notice of the location that was depicted in the building permit application and the actual location depicted by Mr. Polcher's map, that they are different. To complete the exhibit package, we have added as Exhibit M Building Department letter signed by Mr. Golden dated April 19th, 2023, which presumably was a predicate for the current appeal. And Exhibit N and O are the two records that are not Town of Brunswick public records, but these are records that have been prepared by the state of New York. They concern New York State Agriculture and Markets Law Sections 305 and 306 as pertains to assessment issues. And I'll defer to Mr. Chaffee to further address those. We thank the board, and again, for the record, we'd like to note that aside from the last two exhibits, everything we've submitted to the board do constitute municipal records in the town of Brunswick. It's our understanding that these either already have been provided or the appellant would have access to them as well.
Do any of the board members have questions from Mr. Gilchrist about the records he's presenting? I actually have one.
Yes.
I'm trying to frame the question, and you can decide whether it's appropriate for you to answer, whether it's something Mr. Chaffee should address.
Sure.
It looks like in 2017, there were two things pending with the town as far as Mr. Wilson's property is concerned. In your record, you have an amended application for a site plan that came in August of 2017. And then you have the application for a building permit, which came in July of 2017. Two separate things going on.
Correct.
And then you pointed out,
Well, note for the record, not to interrupt you, two separate matters, both pending within the Brunswick Building Department.
correct, but one's a site plan application, which is in front of the planning board, the other's an application for a building permit.
Correct. Both, the amended site plan application had not yet been presented to the planning board. It, to my knowledge, continued to reside within the building department.
We're getting to my question. You then pointed out correspondence between the building department and Mr. Bolson about agricultural use and production and maple syrup and things like that. Was that, and the heading of those correspondence, the subject line references site plan application. Was that correspondence relevant to the site plan application only, the building permit application, both, or not? I was confused about whether or not the questions and answers had anything to do with the building permit
Right.
application versus the site plan application.
It's a fair question, and I presented all the records,
And that's fine.
and I'll
You can't
defer to,
opine on that.
I'll defer to Mr. Chappell.
Okay. Thank you.
Anything further?
Not for me, any board member?
Thank you.
Thank you. Mr. Chaffee.
Good evening. I'm Thomas Chaffee. I'm the Brunswick Town Attorney, and I'm here tonight on behalf of the Brunswick Building Department in opposition to the appeal, which is now pending before the board. We prepared a memorandum in opposition to this appeal, which I'd like to hand up to the board. I have the original here, which I'll present.
Thank you.
And that's a update. I didn't staple it because I thought if we needed more.
Okay.
You'll have a copy for the applicant as well?
Yeah, I'm getting there.
Okay.
Okay, getting back to what I wanted to say, this memorandum, the memorandum I handed up sets forth the legal and factual analysis supporting our position that the appeal should be denied and the determination of the building department should stand. Much of our analysis involves and refers to and discusses various statutes, which might be a little hard to follow without seeing them, so I thought it'd be best to put the bulk of our position in writing, which I've handed up to you. That said, I still would like to make some comments. Put very simply, I think the ultimate issue of the appeal is whether or not the appellant's activities on the subject property as they now exist constitute a farm operation, as that term is defined in the Brunswick zoning law. If they do, then we submit that he is engaging in agriculture as defined in the Brunswick zoning law at section 16012 definitions, that's page 9 to 11 of the zoning law. In an accessory building located on the farm operation and being used in furtherance of the farm operation would be an agricultural building, which would admittedly be exempt from the general 1,500 square foot limitation for accessory structures set forth in the current zoning law pursuant to section 16029A4 of the Brunswick zoning law. Conversely, if the current activities on appellant's property do not constitute a farm operation, as that term is defined in the zoning law, then he is not by definition engaging in agriculture, as defined in the zoning law. It appears appellant disagrees, essentially stating that so long as he claims the building is agricultural nature and is consistent in appearance with other such buildings, that is the end of the inquiry. And it is an agricultural building under 16029A4 of the zoning law, and he is therefore not bound by the general 1,500 square foot limit on the size of the accessory structures. While appellant is correct that there is no definition in the zoning law of agricultural building, we submit that common sense would tell us that an agricultural building is a building used for agriculture. The term agriculture is defined in the zoning law at page 9, the definition of the zoning law. The definition of agriculture reads, agriculture shall include the following. The decision then goes on to list and explicitly define the 7 activities which are included in the term agriculture for the purposes of the Brunswick zoning law. Those 7 activities are farm operation, commercial equine operation, commercial horse boarding operation, compost, mulch, or other biomass crops, timber operation, agribusiness, tourism, and agricultural tourism. Of those, to the best of our knowledge, appellant has never claimed to use his property as a commercial equine operation, a commercial horse boarding operation, or to produce compost, mulch, or other biomass crops. Agribusiness, accessory, and agricultural tourism are only permitted as accessory uses and subordinate to an otherwise activity farm operation and do not appear to be claimed to exist at this location at this time. For reasons I will explain shortly in more detail, appellant's claimed forest agriculture, which he claims to be doing at this point, does not meet the definition of the timber operation in the zoning law. The only remaining item left in the definition of agriculture contained in the zoning law then is farm operation. Accordingly, we submit that appellant's use of this property must qualify as a farm operation in order for it to be agriculture under the Brunswick zoning law, such as would support an accessory agricultural building except from the general 1,500 square foot limitation on the size of accessory structures under section 16029A4 of the Brunswick zoning law. Having said that, I will now turn to the analysis of whether a farm operation as that term is defined and used in the zoning law currently exists on appellant's property. Definition of farm operation is set forth in section 16012 of the zoning law at page 9 of the zoning law. It also appears on page 5 of our presentation. And I'm going to read that definition to you. Farm operation. Such use shall be consistent with the New York State Agriculture and Markets Law and shall mean the land and on-farm buildings, equipment, and milk processing and handling facilities and practices which contribute to the production, preparation, and marketing of crops, livestock, and livestock products as a commercial enterprise, including but not limited to field crops, fruits, vegetables, horticultural specialties, livestock and livestock products, maple syrup, Christmas trees, aquaculture products, woody biomass, and apiary products. A farm operation also includes a commercial equine operation, a commercial bush green operation, a timber operation, and a compost mulch or other biomass crops as defined in this chapter in New York State Agricultural and Markets Law. Such farm operation may consist of one or more parcels of owned or rented land, which parcels may be contiguous or non-contiguous to each other. The definition of farm operation, which I just read, clearly presents two inquiries for a determination as to whether a farm operation exists on appellant's property. They are as follows. One, are crops, livestock, and livestock products being produced? Two, is appellant's claimed farm being operated as a commercial enterprise? That same definition that I read also identifies the types of items that qualify as crops, livestock, and livestock products under the Brunswick zoning law. These include field crops, fruits, vegetables, horticultural specialties, livestock and livestock products, maple syrup, Christmas trees, aquaculture products, woody biomass, and apiary products. Appellant currently appears to assert that he is engaged in forest agriculture. That is a term which is not defined in the Brunswick zoning law or the New York State Agricultural and Markets Law on his property. Specifically, he lists trees, wood products, and nuts. Such items are not crops, livestock, and livestock products as defined in the Brunswick zoning law. Accordingly, we assert that appellant does not produce or allege to produce a crop, livestock, or livestock product for the purposes of the Brunswick zoning law. The forest agriculture that appellant asserts he engages in sounds at first blush like a timber operation, which is also a term defined in the Brunswick zoning law. The definition of the term timber operation is defined at page 10 of the zoning law. It is also set forth in pages 7 to 10 of our memorandum. Timber operation is defined as follows. Timber operation. Such use shall be consistent with that New York State Agricultural and Markets Law and shall mean the on-farm production, management, harvesting, processing, and marketing of timber grown on a farm operation into woodland products, including but not limited to logs, lumber, posts, and firewood, provided that such farm operation consists of at least 7 acres and produces for sale crops, livestock, or livestock product of an annual gross sales value of $10,000 or more, and that the annual gross sales value of such processed woodland products does not exceed the annual gross sales value of such crops, livestock, or livestock products. It's clear from the definition that I just read that under the Brunswick zoning law, any timber operation must be performed as part of and accessory to an existing farm operation consisting of at least 7 acres of land in which produces for sale crops, livestock, or livestock products of an annual gross sales value of $10,000 or more. A timber operation cannot be a standalone farm operation under the zoning law. Additionally, the gross annual sales value of the woodland products, such as the logs, lumber, posts, and firewood mentioned in the definition, cannot exceed the annual gross value of the crops, livestock, or livestock products. The woodland products of a timber operation are separate and distinct from the crops, livestock, and livestock products, which also must be produced on the overall farm operation. We submit that appellant's claim forest agriculture, regardless of whether or not it actually occurs on appellant's property, does not fall within the definition of or qualify as a timber operation under the Brunswick zoning law. In short, inasmuch as crops, livestock, and livestock products are not produced or claimed to be produced on appellant's property, his claimed activities do not qualify as or constitute a farm operation as defined under the Brunswick zoning law. We now turn to the second crime that I mentioned previously to determine whether the appellant's activities qualify as a farm operation. That is the claimed farm operation being operated as a commercial enterprise? The record in this matter is abundantly clear that since August 2017, when appellant first raised the claim that he was a farm operation in the context of pursuing site plan application for a claimed accessory horticultural tourism use, the Brunswick Building Department has repeatedly requested information and documentation from the appellant regarding his claimed farm operation, including the type of agricultural production involved, the amount and location of acreage devoted to agricultural production, the amount of annual gross sales, so that it could fairly and properly evaluate his claim that he was a farm operation under the Brunswick zoning law. A review of the record of correspondence exchanged between the building department and the appellant in this regard has been separately submitted to the board. Those are the documents that Mr. Gilchrist reviewed, exhibits F, G, H, I, and J. Clearly, appellant has never meaningfully and completely responded to the legitimate inquiries of the building department. No documentation of farm product sales, receipts, or farm income has ever been provided. There is no evidence or basis in the building department record upon which it could conclude that the appellant's alleged farm operation is operated as a commercial enterprise. In sum, appellant's forest agriculture is not a farm operation as defined in the Brunswick zoning law, as appellant is not producing or is it claimed to produce crops, livestock, or livestock products, nor is there any proof in the record that he's engaged in a commercial enterprise involving the production and sale of crops, livestock, and livestock products at his said property. Similar to his claim about his structure being an agricultural building, appellant appears to contend that to qualify as a farm operation in an agricultural use under the Brunswick zoning law, a landowner simply has to declare or say he is a farm or intends to farm, regardless of what is produced there and whether the operation qualifies as a commercial enterprise. Taken to its logical conclusion, this would seemingly qualify a single-family homeowner maintaining a small garden in his backyard who sells a few tomatoes to his neighbors as a farm operation in the town of Brunswick, allowing that homeowner to build any accessory structure of any size he wants on his property as an agricultural building, and to avail himself of all of the other protections from local zoning requirements normally accorded to true farm operations, meeting the definition of farm operation under the Brunswick zoning law or the New York State Agricultural and Markets law. Such a conclusion is absurd on its face, rendering the appellant's zoning interpretation illogical and unsupported. It is noted in this regard that the last inspection of the appellant's property by the building department took place in the summer of 2022. A detailed inspection report has been prepared, which was handed up to you as Exhibit L. The report concludes that the inspection did not disclose any evidence of agricultural production of any kind on appellant's site, whether it be maple sap or syrup, trees, wood products, or nuts. I would also like to briefly address another issue raised by appellant in his appeal. Appellant makes much of the fact that the building department issued a building permit for the structure at issue in this appeal on October 17, 2017 for a 2,000 square foot structure with no plumbing and limited electric, which exceeded the 1,500 square foot limitation in the zoning law for accessory structures other than agricultural buildings. The building department later admitted that this was an error on their part. The building department personnel stated that they were not aware as of the date the building permit was granted that the Brunswick zoning law adopted in 2017 contained the 1,500 square foot limitation on accessory building size except for agricultural buildings. The zoning ordinance of the town of Brunswick, which was adopted in the 1950s and replaced by the zoning law in 2017, contained no limitation on the size of accessory structures. So the issue of whether the proposed structure was an agricultural building was not germane to the building department at the time the building permit was granted, as they were unaware of any size limitation at all on accessory structures. We further note that at the time the building permit was granted, the building department and the appellant were still in the process of exchanging correspondence on the issue of whether a farm operation existed on appellant's property. We reject any suggestion that the granting of the building permit was a determination or recognition on the part of the building department that the structure was an agricultural building and therefore exempt from the 1,500 square foot size limitation, or that the town building department is somehow bound or is stopped by its failure to require a variance for the size of the structure at the time the permit was issued from requiring a variance now. It is generally settled that claims of equitable estoppel may not be invoked against municipalities. We also reject any claim that appellant acquired a vested right in this case because he has substantially completed construction of the structure in reliance on the erroneous issuance of the building permit. The courts have consistently held that vested rights cannot be acquired in reliance upon an invalid permit, and that the mistaken or erroneous issuance of a permit does not stop a municipality from correcting its errors, even where there are harsh results. In this case, the permit was invalid, in that it permitted an accessory structure which exceeded the general 1,500 square foot building size limitation for accessory structures in the Brunswick zoning law. Finally, we note that the structure appellant actually built deviated substantially from the building department plans that were submitted by the applicant and erroneously approved by the building department. Our case authorities are set forth in our memorandum, and we also expound on the various arguments that I just touched on here.
Anybody have any questions, Mr. Chop?
And that's,
And I would confirm that the exhibit that was handed up to the board, which was the one exhibit, I don't remember the number of the one, which a report of Mr. Gold, the code enforcement officer, that was prepared without our knowledge or involvement. I knew nothing of it until we came across it when we were searching for documents. Thank you.
So I think you have two options. Option one is you've heard from the applicant, you've heard from the building department. Option one would be to open up to anybody else in the public who wants to address the board on this appeal. And then when that's done, offer an opportunity for the applicant to supplement his presentation with anything else. Or if you wanted to, you could, option two, you just go straight back to the applicant while the building department's presentation is fresh. Let the applicant say whatever they like to say, and then open it up for general public comment. But I'm not sure if it's preference. I'm not sure how much general public comment there will be, but I didn't want to forget that there were other folks who they wanted to address the board.
right. And then after the public comment, could the applicant then respond or?
So in some ways, it might be helpful that everybody at least speak once.
Yeah.
That way, if there is something that comes out of the public comment that TJ would like to respond to, he's aware of it, so we're not coming back for it.
Right. All right, so let's do that then. So we'll open the floor for any public comments other than the perspective of the town or the applicant's perspective.
So ma'am, I know you expressed an interest in speaking before. You don't have to, but if you'd like to, this would be the time.
I truly admire Mr.
I
Goldsmith's
think we need this to come up. And maybe, just state your name and address for the
Oh, okay.
record.
I'm the Parker, 836. And I admire Mr. Wilson's entrepreneurial endeavors. We live on the back side of him, and it's nice and it's quiet, and that's why we moved there. And it's in rural ag zone, something like that. And we requested to put up an accessory structure to house our equipment. And we did get a variance, which is what was required. And while I would like to think we could do anything with our properties, there are zoning things in place to keep us all on the same page. So I think if his property is the same as mine, the rural agricultural, then the thing to do to solve it would just be for him to get a variance to put up the larger structure. I don't see it as agricultural. I grew up on a farm. It's not agricultural. So that's fine. And I think if it were to go the other way, and then there were some tourism things in there, it would add to the noise and traffic level, which I would not be very good. So, that's all.
Thank you for your comment.
Would it be possible to know that lady's name? I didn't get it.
Don Parker.
Thank you.
Would anybody else like to speak? So hearing no other further comment from the public, I offer Mr. Bolson's attorney a chance to respond.
Absolutely, thank you very much. And thank you, Ms. Parker, for your comments. We agree, the zoning laws exist so everybody can be on the same page. And that's what we're talking about here, is what's on the page of the zoning laws, okay? The town presented an awful lot of information tonight. It would have been nice to have that prior to tonight. It would have been nice to have the town's take on this whole issue prior to tonight, so we would have a meaningful opportunity to address it. As the board is aware, we've been engaged in this process for almost 2 years now, writing consistently letters, putting our position out, citations and letting the town and the board know what our position is. And it's not till tonight that we get an enormous submission by the town with voluminous documents and finally their interpretation of what we've been talking about for 2 days. So I'll lodge, I guess, an objection to the fact that this hasn't been presented before tonight so that we would have some kind of a meaningful way to address it. But I'll do the best I can for now. Everything that was talked about tonight, the one thing that was lacking, the town attorney, Mr. Siafi, talked about how common sense would find that you have to interpret it in a certain way. One thing that was lacking is any citation to the actual statute at issue tonight, which is 16029. There's nothing in there about a farm operation. There's nothing in there that says anything about an affirmative showing for the admission. For the exemptions. Checking the notes here. But what is in 16029 is a citation to the, I have it down here, and again, this is why it would have been nice to have this before tonight. What is in 16029 is a citation to the New York State Department of Agriculture and Markets. Okay, and I'll read it for the board's edification. Except for structures used for agricultural purposes, and this is 16029, when conducted using sound agricultural practices as defined by the New York State Department of Agriculture and Markets, okay? And so section 308 of the New York State Agriculture and Markets Law refers to those practices necessary for on-farm production, preparation and marketing of agricultural commodities, which includes, quote, operation of farm equipment. Okay, and under that definition, which is actually cited to in 160.29, Mr. Bolson operates farm equipment. And therefore, without having to reach out in some kind of ad hoc way to other portions of the zoning law, Mr. Bolson qualifies for the exemption under 160.29 based on 160.29 itself. As I said before, any ambiguity is to be construed against the municipality and in favor of the landowner. And what we saw today, what we heard tonight, was a justification by the town to try to justify the position that they've taken. Okay, these are smart folks. They clearly were able to come up with a justification, but that is not anything that was expressed to Mr. Bolson at the time, and it was not expressed anything to Mr. Bolson within the last 2 years. It's something that was as far as we know, brand new tonight. The other thing that I think is interesting is that they seem to be taking inconsistent positions tonight. On the one hand, they take the position that, the town was trying to get additional information from Mr. Bolson all along by asking about his farm equipment, by asking about what he was doing on it. And at the same time, they're also taking the position somehow that Mr. Bolton simply made a mistake. And the original application was just made in error because the new zoning laws had a restriction that the old ones did not. Okay, so what it seems like to me by taking those inconsistent positions is the town is just trying to come up with a justification now for the position that it's taking. Again, with regard to the first position that they're taking, that Mr. Bolson has some sort of a duty to provide some kind of affirmative showing of the operations, that just does not exist within the town law. Okay, we've asked for that. Mr. Bolton has admitted that doesn't exist. I think the folks in the board probably know by looking at the town laws, there is no requirement for an affirmative showing. There's also, as the town has conceded tonight, no definition of an agricultural building, which is why they had to reach out within the zoning rules for this farm operation. But I submit to the board that that's a red herring. There's nothing in 160.29 that refers to any type of showing that has to be made under a completely different section of the zoning laws. There's nothing in there about an affirmative requirement. And like the public comment tonight was we got to look at the zoning law so everybody's on the same page. And that's what we're doing. 160.29 doesn't refer to anything else except the statute that I referenced. He meets that. The stop work order, let's talk about that. When the stop work order was submitted, the only thing that was that it listed as its basis was changes made in the construction of the barn itself. There was no complaint about any kind of showing required for the farm operations. There was no request that substantiate that he is a farm operation. There was no citation to anything that was mentioned tonight about the interpretation of the zoning laws. It was that he had changed the structure of the building and that he was above the 1,500, and that was it. All of what we heard tonight, we submit is a post hoc rationalization for the position that the town has taken. And so those types of post hoc rationalizations are by definition arbitrary and capricious. To the extent that the town wants to have something like that, it can provide it. It can do it, which it tried to do last summer, 2 summers ago, when it at least proposed amending the zoning laws to require some sort of affirmative showing. They had the chance to do that. They had the right to do that. They didn't do that. So to the extent that any kind of affirmative showing is required, if the town wants that, they can do that. But it doesn't exist now, and it didn't exist when Mr. Bolson was given his application to begin with. Mr. Bolson's activities, we heard tonight in the record, he has represented that he has in the past done some maple syrup business, some agricultural maple syrup. That's in the record. That's one of the things that Mr. Ciaffi cited to as a legitimate farm operation, even if we go down that path of interpretation, which again, I submit is not proper. But again, even those type of affirmative showings ignore the fact that requiring you to prove some type of business before you have the structure is putting the cart before the horse. All right, if somebody's gonna have a dairy farm, for example, would they have, if they're building the farm, they have no product yet. And this all seems to stem from a fear of this tourism business that was taking place back in 2017. Mr. Bolson considered it. He abandoned that project. I believe in August of 2017, the town killed that project. The board's decision, when it makes it, cannot be based on fears of some type of business that might happen in the future. It has to be based on what actually exists. And it has to be based on the evidence that's before the board. And that evidence is that Mr. Bolson has no plans to run a tourism business. He has no plans to run a bed and breakfast. And the physical structure that we're talking about today, and Mr. Golden has said this, and it was in the notes that we reviewed tonight, is that there are minimal plumbing, there's minimal electricity, there's no sewage. This is not a B&B. It's a barn that Mr. Bolson is using to house his farm implements. It's going to use and to help him do whatever type of agricultural business he would like to do in the future. There is no tourism business, there's no B&B, and the board's decision has to be based on the record before it. It has to be based on what's the position the town has taken before, and it cannot be based on some type of presumption about what is going to happen in the future. That's all I have. If you have any questions for me, I'm happy to respond.
So, Mr. Tejan, you did mention a couple times that you candidly only received the town's written response this evening.
Correct.
I can appreciate the fact that, despite your attempting to respond to it on fairly short order, you haven't had a chance to go through it. If you wanted to make a request, I suspect that the board would entertain a request to leave the public hearing open for a written submission if you felt that was something that the applicant wanted to do. On the other hand, if you're comfortable with what you presented here tonight and don't see the need for it, that's fine too, but I want to at least offer that opportunity if you want to make that request.
Thank you. I do appreciate the offer. I'd like to confer with my client, and can I let you know, or does that have to, the decision has to be made tonight?
Well, I think typically I'll leave it open to this. So we could hold the public hearing open and you can come back and make a submission.
If I could get just a couple minutes, and I'll give you a decision by the end of the meeting, that would be great. Any other questions, folks? Thank you very much. I appreciate your time.
Well, while you're still in the room,
Oh, sorry.
can I approach?
Certainly.
And this is not, again, Andrew Gilchrist for the record, this is not with respect to the zoning analysis presented by Town Attorney Chaffee. There was a statement made by Mr. Teachin concerning the proposed amendments to the Brunswick zoning law. I was involved in the preparation of those proposed amendments. I don't know that it's accurate. The description of what the proposed amendments pertaining to agricultural uses by Mr. Teachin is accurate. I'd like the board simply to, if you're inclined to do so, review the record of those proposed zoning amendments with respect to agricultural uses. Thank you.
Well, just maybe for the benefit of both sides.
Sure.
I don't know, and again, speaking as terms here, not a board member, but I don't know that the ZBA members are going to on their own go out and investigate proposals.
Well, all I wanted to do, not to interrupt you, was to clarify that there were representations concerning what the proposed zoning law amendments considered by the Brunswick Town Board in the summer of 2022 included. And I don't know that that accurately reflects the proposed amendments pertaining to agricultural uses. We'll leave that at that. And I will note as well, again, not with respect to the zoning law analysis directly, but there was discussion by Mr. Teachy concerning startup farms. And we'll just note for the record that the Department of Agriculture and Markets does address startup farm operations and what are required to be considered a farm operation under the state ag and markets law.
I will say that while I certainly can make mistakes, I don't think that I did with regard to my characterization of the zoning law. I would, submit that I too would have the board, to the extent possible, simply review the red line changes that were offered for that, and I'll stand on, that they are what they are.
So do you want to
Yes,
get back to us? Take your time, but we're just gonna, I think then the decisions to do,
Yes.
sort of deciding what we're gonna do.
Thank you.
Sure. Take your time.
Yeah, I think so.
Appear to have any minutes, we're just gonna stop by the.
With your permission, Mr. Chairman.
Certainly.
Yes, so we would like an opportunity to respond. We would propose October 2nd for the deadline for the submission, and at which point the public comment could be closed, and we leave it open, I guess, just for written submissions.
So you're saying October 2nd would be the date by which you
We
would
would-
submit
Correct.
whatever response,
That's correct.
and then that would be it?
Correct.
And theoretically, that same opportunity would be offered to anybody who wanted to submit public comment. October 2nd would be the closing date of the record.
Correct.
And just to clarify, under both New York law and town code, once the public hearing is closed, the board has 62 days to issue a decision, unless that date is extended by agreement. If we're going to hold the record open for your submission and any comment until October 2nd, I would propose that we agree that the 62-day period run from October 2nd. Any objection to that?
We would assume that,
Okay, just confirming so that we're all on the same page calendar-wise.
yes.
So, by the way, it's not up to me, it's up to the board. Is that acceptable to the board members?
Certainly.
Yeah.
Yes.
Excuse me, can I be heard for a moment?
Certainly.
I'm sorry, were you done?
Please.
We have no objections to leaving the hearing open or providing a period to file comments. I first want to say that, I spent some time in front of the zoning board here, and I wasn't aware of any requirement that I was supposed to have papers in advance. And I'll be honest with you, they were just completed yesterday. So, it wasn't any intention to try to give somebody a hard time or do something discourteous or anything like that. It was, I wasn't aware of, I didn't get anything that indicated that there was a time requirement, that the papers had to be filed and given to somebody within a particular time. So that's my explanation for that. You know, as I said, we don't have any problem with extending the public hearing, keeping it open, or having the time for the appellant to respond. I was just wondering if you're gonna do this 10-day period, can anybody respond? Because Mr. Teachin said some things that
Correct.
maybe we might want to respond to.
So, Rob, when you say you might want to respond, you mean get something supplemental in by October 2nd?
Yeah.
Or are you saying respond to what the applicant?
No,
may
I mean, if you're gonna leave it open to have something else come in, all I'm asking is whether or not we'd be allowed to submit something too. I'm not saying wait for his, I'm saying,
Correct.
we've heard enough tonight, we know what the position is.
So again, up to the board members, you know, my inclination, I think as I indicated, would be that you're closing the public hearing tonight, but you're leaving the record open until October 2nd for any further submissions by any interested party, whether that's the applicant, the building department, or any member of the public who wants to express their views to the zoning board. Whatever comes in by October 2nd comes in. At that point, the record is closed and fully submitted, and that will start the 62-day clock for this board to issue a decision.
Okay, if I could just ask again to clarify, because I don't want any further misunderstandings. If we do submit a comment, do we send a copy to the appellant?
I think that would be helpful, and
Will they send one, will they agree to send it?
And so that's the two of you, right? So you'll provide to the board, you'll copy each other.
Copy each other.
If the board happens to receive any written comment from somebody other than you folks, I'll ask the board to make sure I get a copy, and I will forward it to both of you as well, so everybody's seeing the same stuff.
Works for me.
We agree, thank you.
No, it's indicated in the minute, so it should be fine. So I think what we do, again, unless there's any other business for you folks at this public hearing, I think we now officially close the public hearing. Again, subject to the extension to October 2nd for the submission of any additional written comment, and that will probably conclude this application for tonight.
I have one question before we close it. Now, I haven't had a site visitation, I wasn't sure whether we've been granted permission to visit the site. Would it be all right to get permission to visit the site for the next meeting?
So, you know, I just want to talk a little bit about what you have in mind. Okay, so this isn't, for example, a variance application, right, that you guys would typically handle, where maybe going out to the site and looking at the topography and the layout might help you decide whether the variance is substantial or not substantial, or the other criteria that you have to adopt. So this is an appeal based on the interpretation of the code. Two different perspectives.
So site visitation might not be appropriate.
Well, if you felt that it was important for you to see the site to be able to render the decision using your best judgment, then we can have that conversation. If it was just, we usually go to see the site when we have these applications for variances, and we should do that here too, then maybe there wouldn't be a problem. You see what I'm getting at? So I guess the question is, do any of the board members feel that a visit to Mr. Bolson's property would be relevant to the determination of this pending appeal? If the answer is no, not really, then there's no need for a site visit. If the answer is yes, I think it would make a difference in terms of how I do decide this, or it might, then we can have that conversation.
My only concern was it was brought up tonight in the discussion that there's a discrepancy between a survey and then where the building is built.
So, and again, if I say anything incorrectly, one of you two folks are gonna correct me. When the stop work order was issued, I think there were a number of items that code enforcement believed Mr. Wilson needed to resolve to move forward. One of those was this issue of whether or not he needed to apply for a variance. There were other ones related to survey, updated, whatever. I believe, if I'm correct, that the other issues have all been resolved at this point, and that the only issue being raised on this appeal is the area variance issue. So I don't know that this board needs to decide anything other than on a code interpretation issue, whether the applicant is or is not required to obtain a variance to put up his accessory structure. So does that resolve your issue about why you might think a site visit?
Oh, absolutely.
Okay, I wasn't sure. Did I get that all correct
Yes, correct.
from both sides?
Again, it will confirm, you are correct. I'll just note for the record, that's included in the exhibit package at Exhibit M,
The April 19th,
April
2023
19th,
letter?
2023 letter. It does confirm 3 of the 4 items were addressed. The only outstanding item that needs to be completed is the area variance. So that's the smoke issue.
So with that point having been discussed, we're back to the question of whether or not any board members believe that a site visit is necessary for the resolution of this issue.
I don't know.
You brought it up, what do you think?
I would feel more comfortable looking at the barn as a farm. I would like to judge the barn as a farm building or not. But if you think it's inappropriate, I'll back off.
It's not what I think, but here's the concern a little bit, which is the criteria that you guys are gonna apply to decide this appeal is really based on code interpretation on the facts in front of you. So you might come to this with your own specialized background knowledge in farming, agriculture. You may have a sense of what looks like an agricultural building to you. But that's not really what you're gonna be able to use to decide this. You're kind of stuck with the way the code is written and reasonably interpreted based on facts in front of you. So what I wouldn't want you to do is say, I don't care what the code says, I'm denying this appeal because it doesn't look like an agricultural building to me. Or the opposite, I don't care what the code says, it does look like an agricultural building to me. So that's what I worry about, confining ourselves to the task in front of you guys, which is really code interpretation.
Right.
But if, understanding everything I just said, you still felt that a site visit would be helpful to you and your board members, and we could still have that conversation. I'm not here to talk you out of it, I'm trying to make sure you understand how a site visit fits in with what it is you guys are trying to do. Does anybody want to address applicants about the aspects of a site visit, whether you have a perspective of whether it's a good idea, bad idea?
Sure, I mean, we certainly have nothing to hide. I would maybe surprisingly agree with your assessment that
Not surprising.
the issue before the board is what's been presented in the record. Mr. Golden's been out to the site multiple times, he's taken photographs, he's recorded his observations, and I do also agree that this is an interpretation of the code and whether it's a reasonable interpretation for the task we're taking. And so, I think that the site's been visited multiple times and there's multiple pictures within the record, and we would stand on that.
So, I guess we do a couple of things. If everybody now feels content that there's no need for a site visit, we can simply acknowledge that and move on. On the other hand, if one or more members are still considering that as a site visit, I suppose we put it to a vote. Right? What I wouldn't want is for one board member to do a site visit but not have everybody go. So is anybody at this time prepared to make a motion that the ZBA members conduct a site visit as part of this appeal?
No, I back right off to look at it.
Okay, so No motion, sounds like we're all resolved, that there will be no site visit as part of this process.
Right.
So unless there's anything else, I think we're probably all set.
So,
Motion to close the meeting, or how do you guys usually wrap these things up?
I guess we will ask if there's any other information.
Excuse me, is the public hearing being closed? Because
Correct.
maybe if, should that be done formally by vote if you are?
Yeah, so I think it'd be a motion to close the public hearing, subject to the record being held open for further written submissions by October 2nd.
Right, so I make a motion to close this portion of the application as a public hearing, subject to the record being held open for the submission of written responses until October 2nd.
I'll second that.
Thank you, John. All in favor? So the public hearing has been closed. We'll make a motion to adjourn tonight's meeting with a member second. Thanks, Darrell. All in favor?
Aye.
Thank you. Good night, everyone.
Thank you.
Thank you. Thanks for coming.